This episode of Off the Cuff is brought to you by Waiver Simmons, and we're very pleased to bring it to you. I hope you enjoy.
Welcome to Off the Cuff. I am Matt Butler.
I'm Darren Chohan.
So on today's episode, we're going to be discussing waivers and releases.
And waving is not just
we're not just
waving at each other, you know?
No, we've all read them. We've all signed them. Oftentimes we don't read them when we sign them. And today we're going to talk about what's in a waiver, what is a waiver, what's in a waiver. When you sign the waiver, are you waiving around all your rights and obligations, or like what essentially are you signing off on here?
What's most important is the fine print.
It's always the fine print.
And
we live in the fine print.
We have to ask ourselves, if I don't read this fine print and I sign, what happens?
Yeah.
And that's what we're going to get in today. Why the fine print matters.
Why the fine print matters. I like that. That's a good topic. So just generally, Darren, since you're the civil litigator out of the bunch, what is, in general terms, a waiver?
So a waiver can appear in a number of contexts, right? You can sign a waiver when you take your kids to the trampoline place. You can sign a waiver when you go snowboarding. You can sign a waiver when you go skiing. You know, if you sign up for the Boston Marathon, there's probably a waiver that you have to sign when you're running the Boston Marathon. I don't know. There could be, there couldn't be.
There could be.
But any types of activities that pose a risk to you, yourself, or others, typically come with an acknowledgement that that risk is your own problem, not the problem of the venue or the group of people putting this on. And so oftentimes that's why you're asked to sign a waiver. And in today's day and age, actually, what more and more is happening is you show up to a place, you purchase your entry, and there's an iPad in front of your face, and that says, hey, click this button, sign your name digitally or with your finger or whatever, and move on. And you can go into our facility and do the things that you paid your ticket to go do at the moment in which you buy your ticket. So that is generally speaking of what a waiver can accomplish. The fine print in the waiver, however, is what really matters. And so if you sign a waiver, it's you're likely signing away your right to sue for personal injury. And that's where it becomes really important to really understand what you're signing, what context you're signing, and how that waiver comes to your attention.
And what kind of language is in your traditional waiver?
So usually you'll see something along the lines of, please read this carefully. You are assuming all risk for entering onto property to perform X activity. And it'll say it should say, this is where we get into the problems with waivers. A good waiver will say, by signing this release or waiver, you will waive or give up certain legal rights, including the right to sue for a claim for compensation following an accident. And then it'll tell you to read carefully and go on to show you where the company is actually reducing their obligation to you to keep the place safe. And that whole discussion revolves around our Occupier's Liability Statute. And in the Occupier's Liability Act, which this episode might get a little legalese, but it'll try to keep it, lay and for people to understand. But the Occupier's Liability Act is our piece of legislation that simply says that anybody entering onto the premise must be kept reasonably safe.
Right.
And it's the obligation of the occupier and owner, depending on if it's a leased place or not, to keep wherever you're going safe. But also in the Occupier's Liability Act, there's a section that says, well, you have an obligation to keep the premises safe, but you can also create a contract that says that the people entering onto this premise are acknowledging the risk of performing said activity. Right. And that's what the waiver is meant to accomplish.
Now, can an occupier or an owner in their waiver have any attendant or participant in the venue or whatever they may own or occupy all of the obligations, any sort of legal route? Can they make someone waive all of those things?
Yeah, and typically the case law here says that the more onerous the waiver,
right,
the more attention the person wanting you to sign the waiver has to bring to those clauses in the waiver. So if they're really out there to say that you cannot sue us for absolutely anything, doesn't matter what happens to you, you could become a quadriplegic, which happens, and we've seen that in case law, and the waiver is held up.
Right.
Because they will have in their waiver pointed you specifically to the language that says we are not responsible for anything that happens, even if it's due to our own negligence. Because what happens is there could be a finding of negligence, but the waiver protects you from being sued.
Right.
So even if you were negligent,
you've assumed the risk notwithstanding.
You have, as the patron, assumed that risk notwithstanding. There was negligence on behalf of the parties that were involved in setting up this event or race or whatever it may be. And so it really boils down to the administration of the waiver. Right. So that is just as important as the text of the waiver, because let's be honest, nobody reads the fine print.
They should, though.
They should, but it's not fatal to the plaintiff's case if they don't fully read it.
Right.
Because as long as the waiver itself has all of the checks and balances, and I should say, sorry, it's not fatal to the plaintiff's case, but it's also not fatal to the defense if the plaintiff shows up and says, well, I didn't read it.
Right.
And that's not how you succeed in these cases. Reading it is not necessarily the test. It's would a reasonable person in those shoes of that party have noticed the provisions that are in place to prevent the lawsuit.
Now, there's a case that if any law students are watching this, or any lawyers, there's a Supreme Court of Canada case that laid out sort of not the criteria for waivers, but that a waiver in and of itself is not enough to cease a claim. And that case is Crocker versus Sundance. Yeah. So why don't you tell us a bit about what happened in that case?
So in Crocker and Sundance, that was a gentleman who attended this ski hill and entered a competition, signed a waiver without reading it, paid the entry fee, ended up getting injured and becoming a quadriplegic. You know, background story a little bit, the guy was intoxicated and there was an issue as to whether or not the park or the hill had a duty of care to ensure that they didn't have an intoxicated individual running the race or entering this race. But on the issue of the waiver, specifically in this case, it said that the waiver did not preclude him from suing because the waiver in the language did not point to the assumption of risk removing the negligent conduct, right? So there wasn't enough language satisfactory in the waiver to a reasonable person, not this guy because he hadn't read it, but to a reasonable person because it had not been drawn to the attention of the entrant that they could contract out of negligent conduct. And so that case then finds that there was a duty of care owed and that was an important case in tort law. But for the specifics of today, really, it's important to know that waiver in Crocker and Sundance, and we'll put the link to the case if people are interested in going to read it, was held to be not sufficient.
Right.
And that's, of course, we're talking now, that's a 1988 Supreme Court of Canada case. So it's older, but it's still good law. People still rely on it.
It's a lesson learned in that, yeah.
Yeah, and have interpreted it further. And you get to today's realm now where really it's two parts, like I said. One, where the waiver itself needs to have the sufficient language. And number two, it's how to administer your waiver and to really protect you as the business owner or the person planning this event from liability, and how to do that and how to instruct your employees to go about that.
So what would you say is the best practice for somebody who's interested in either administering a waiver or even considering it for their business? And what's the sort of the basis of your opinion on this one?
So I think, this would be the second part of the waiver, and that's, if I'm putting on an event and I'm a business owner and I want to make sure that these waivers are going to be upheld and I really want to protect myself, I'm going to be telling my staff, and I'm actually going to have my staff explain this waiver to each patron and say, this is a release of liability and a waiver of claims. This is a legal document. It's a contract. Make sure you read it and understand it and know what you're signing. And then have your employee instructed to be the witness of that signature so that twofold, later on, if a lawsuit is brought, your employee can say, well, that's the practice that I follow with every single person that walks in the door. There is no reason in my mind that I would have deviated from that practice for this specific individual. And therefore, I can say with this very sufficient degree of certainty that I would have asked those questions and my signature appears on that document. And therefore, I would have explained the importance and the nature of this waiver to them. And I would also instruct them to say that until the patron acknowledges that they've read it and understood it, that is when the signature of the witness can be affixed to the document. Otherwise, that person is not permitted entry into whatever facility or business or park or whatever happens to be. So that's why I would do that, because it gives you in the event that somebody gets injured, you and I both know that the person's going to sue likely anyways, irrespective of if they sign the waiver, because they're going to say, well, I didn't read it. I didn't, I just signed it because they told me to sign it.
Or it didn't capture all everything that could have happened.
Right. So
all risks.
Let's try to get it into one of the risks not captured. And so if you can say, produce my employee and say, even 5 years ago, this is my employee, but I was trained specifically to do this, then that's very, we always talk about having the best evidence. That's an indicia of having the best evidence available to say, look, we have the individual who signed that document and they were trained in this fashion and this is all they would do. And there's no reason to believe that they didn't do that in this case.
Now, that was great advice. And I'm going to sort of peek behind the curtain here. It's not all off the top of Deeran's head. There's a specific case that those were the fact patterns. Yeah. That the waiver was explained by the employees to the patrons. They only witnessed it when the actual patron read the waiver, and they went through that whole process that you just explained, and that was their defense, and it essentially had the claim dismissed because of how solid the waiver was. The circumstances leading up to the signature of the waiver and the waiver itself. It was bolded in the contract. It had in all caps and in big, please read carefully. And like you said, the staff were on top of it and were well trained in discussing, like you said, this is a waiver, like a liability waiver and claims. This is a legal document. It's a contract explaining all of that. So it was a case out in BC that was then adopted in Ontario.
Yes, and so we'll post the link to that case too, because it's a very good one, and it gives you an insight into how these things go down and what can happen and the injuries, and really it's a sad situation that this person is severely injured, but they're essentially not statute barred, but they're waiver barred from bringing the risk because they've assumed the risk of the injury, and you see a lot of these cases originate in BC because that's where you go to ski, and Whistler's out there, and a lot of these cases are in Whistler or come out of Whistler.
Actually, most cases we thought we were from BC.
Yeah. So in preparing for this, a lot of it, but there are lots of Ontario ones. But the critical piece is that the Ontario ones actually look to the British Columbia law to inform the decisions here, and that's just a little legal lesson is how the common law works. Right, that's we're part of the Commonwealth, and our provinces are not precluded from relying on each other's precedent to inform themselves to make decisions, while the law itself statutorily may be different. We're blessed to mostly across the provinces, the Occupiers Liabilities Acts are standard. They're very close.
Yeah.
So our occupiers liability law across the provinces is very close. And while each province might have its own set of specific rules or the way they deal with it, other provinces can look to each other for help. And so in specific cases like this, we see a lot of cases come out of British Columbia and good cases that come out of there. So that being said, I've been talking a lot. I think let's take a break and we'll get back into it after that.
So Darren, we've been places, recently we went skiing, where you have to sign waivers and there are signs everywhere. Now, is there a difference between going to a place, receiving a waiver document and signing it, or just buying a ticket and up on the grounds or the ski hill, you see signs posted everywhere? Is there a difference between those two situations?
So there actually is a difference with that. And the first example where you're signing a waiver, and we've talked a little bit about that, when you actually physically affix your name to a document, that, that's a one type of waiver. But the other type of waiver is just as you described, you show up to the ski hill, on the back of your ski lift ticket, you've got all of their language on there that limits their liability, or they think it's going to limit their liability.
More fine print.
More fine print. And then you have signs posted and posters up talking about, we're not responsible for injury. This side of the hill is dangerous. The other side of the hill is not dangerous. There's a big jump on this one. There's, so all of those situations exist, and every hill is different, in what posters they put up. So, if you're talking about, wanting an opinion on, you want your waiver to succeed in a setting in which, you're just showing up, buying a ticket and going forward. I think the case law has said, as I said earlier in this, the more onerous the exclusion of liability clause, the more explicit the notice must be. And so what that means in the form of posters, that poster better be huge, it better be visible, and it better be in bold letters, yellow, red, whatever you need to do to make sure that if I'm riding that ski lift, that's something I notice while I'm riding up. And it doesn't have to be you as the person. It's would a reasonable person sitting on that ski lift see that. Then when you get to the top, a reminder, hey, the hill you're about to ski has this dangerous jump. We're not liable for any injuries that you receive as a result of taking this jump, et cetera, et cetera. So the more onerous and the more visible you make these notices, the more successful you'd be able to be in defending a claim. And obviously, the form of the notice too. So it has to also not just be use at your own risk.
Right. Because you see that often. Use at your own risk. Yeah, you see that at pools all the time. Yeah.
So that's nothing. That doesn't tell you anything. If your goal as an owner or as somebody who is controlling that area to avoid liability, use at your own risk doesn't help you avoid your liability. What helps you avoid liability is saying explicitly in bold letters, you are assuming this risk. We are not responsible for anything that happens to you, injury or otherwise, as a result of yours or our negligence.
Right.
Something along those lines. And of course, that's not the exact language. Consult a lawyer before you're going and exploring these things. But typically, you would want to have those words, the trigger words in your notice, your signs and whatever, to ensure that patrons are very well aware that they will not be able to sue. And it's nothing to say by taking on this risk, you are waiving your right to sue. very simple language, but it's clear and in big letters, and you can see it. The other little piece to that, however, is the circumstances of the plaintiff in a lawsuit of this nature are taken into consideration. So the court will look at the plaintiff's age, education, previous experience with waivers or similar recreational activities to determine what a reasonable person in the plaintiff's shoes.
Right. And that you've said, and you've said reasonable person a few times. That actually is a legal test in these analysis. You have to take the person as is, but in a reasonable, we'll say a reasonable person in the plaintiff's shoe, like you said. So that's actually a legal test in negligence claims and a lot of tort claims, like the reasonable person. Mm-hmm. It's trying to make an objective standard in a otherwise fairly subjective world of litigation.
What is the old English term? It's the person on the Clapham omnibus or something that.
Wow, you remember that? Good for you, from law school.
Yeah.
Wow.
So that's like when we're learning for tort law, that's what they did. Yeah. Like, I'm going to ask you, viewer, do you know what a Clapham omnibus is? Because I sure as hell don't.
I don't.
So
it was a cool saying then.
Maybe it's Lord Denning telling us that we should, be well versed in the English language. I don't know.
Sure.
But anyways, I digress. So that today, the reasonable person is just somebody in a similar set of circumstances who would have the same faculties as the person they're evaluating would approach or view that situation and what that result would be. And that is, of course, as Matt described, the legal test that we use in negligence law. But when you're into these lawsuits, you're into negligence. So that's a little background on like the you see the waiver language on the back of your ticket, and I'll just read something quickly to you guys. It's a little quote from one of the cases, which we'll post in the description below. But here, the judge says at the trial level, it was unrealistic to believe that a person approaching the ticket booth would stop in front of the window to read the sign. It is positioned away from where the purchaser is focused in order to make the transaction. The ticket seller is not instructed by the plaintiff to say anything about the waiver to the ticket purchasers. And then it goes on to say the waiver was virtually in the same language on the back of the ticket. But in that context, it was found in this case that it had to be remitted back because this was on appeal. But the appeal court had real issue with the trial judge saying, well, no, he would have known, he should have known, the reasonable person would have known. It was overturned on appeal because of that commentary there, basically saying that a reasonable person in the plaintiff's shoes, actually the trial judge made a mistake, probably wouldn't have noticed that, and then it was remitted back.
That's why your advice of big signs, bold letters, up the lift.
And your employees are so critical to...
Very much so, in the training. So we're not going to get into employment stuff, but training your employees properly actually could save you as a business owner quite a bit
from a claim, because if you can show in your training policies and procedures what you've done, what you do, what you can do for your patrons, that's all going to be good evidence to show that you've done everything you can possibly do to warn these people of injury and risk, and then they assumed it anyways. And that therein lies where the lawsuits come and go, and that's where you'll determine a successful lawsuit from a not successful lawsuit from the plaintiff's perspective, is if you see a sign saying use at your own risk, well, you're probably going to be successful in suing if that's all you see.
Sure.
But if you go through the analysis that I just talked about, that plaintiff's going to have a much harder time trying to establish, not even establish negligence, because you can establish negligence, but to make out your claim for not being barred from actually commencing the lawsuit. So that's just the example for the language on posters and stuff. All of those same principles typically apply to the signed waivers. There are exceptions for the signed waivers, because when you sign a waiver, effectively you're entering into a contract. So that's kind of the difference between the two, where a signature is a contract between both parties, whereas this buying your ticket creates a different kind of contract, but it's not the kind of, waiver contract necessarily that you're signing. So, the law surrounding signed releases says that a person that signs the release is bound to that release unless these factors exist. And again, we'll post this case for your review afterwards. But there are, as an exception of what's called non-e factum, which is the person is mistaken as to the nature of the document. So the plaintiff would have to prove, well, they were misled to believe it was something else. Again, the next exception is fraud or misrepresentation. So you were induced to sign it by fraud or misrepresentation. Objective lack of consensus ad idem, which is where it's unreasonable for a person relying on the contract to believe that the signing of the person signing the contract agreed to the terms. Unconscionable was the contract formed in unconscionable circumstances, i.e. under duress or pressure, forced, etc., which is why very important in your waivers to include a clause that says you have had sufficient time to read this document and understood it, which goes back to the advice on training your employees. And then the last is public policy, where there would be a strong public policy element to enforcing this contract or not enforcing this contract.
Right.
And that's, of course, a legal test undertaken by a judge at a trial. So those are that would be, what you're looking at versus a signed waiver and a non-signed waiver. But I think that gives a good flavor text to what you can expect from waivers. So the next time you take your kid to the trampoline park, read the fine print and see what it says.
Can you guys tell he's been working on waivers this week?
Yeah, I guess I could talk for a long time because this is what I've been doing. But no, truly, it is interesting.
No, it's good, and it's good to know because there's too many times where people they look at it, they sign it, and they just forget about it, or you just see like posters around, you go, okay, but whether or not that would stand as a legitimate waiver, like you said, there's an analysis to be made. So that was
in every context.
Yeah. So let's talk about releases now.
So what is a release, Matt?
So a release is typically after a claim is done, or it could be prior to if you're giving up a claim. And you're essentially releasing the parties from opening up either an action or an application or a court matter, or just a matter in general. So the example is after, we'll say, a settlement, you have full and final release from both parties saying this matter is done. They're not going to reopen the matter. They're not going to seek anything further. We see it in family law cases all the time where if they're admitted to settlement or a separation agreement, if people want to keep their property, as long as there's full and frank financial disclosure and ILA, like independent legal advice to ensure that you know your rights and obligations and what the regime does look like and what you're essentially waiving or so releasing, then you can have a full and final release within the agreement. There are exceptions to that. The biggest one in the family law context is spousal support, but we'll touch upon that later. So what kind of releases have you seen or what you've dealt with that?
So I think from a release standpoint, and exactly like what Matt said, is typically when is after a settlement. Usually you would sign a release after you've settled
in the normal
course, the normal course, and one party is receiving compensation on a contract or in the settlement, or properties being exchanged.
Yep.
And you'll either have mutual releases, which are both parties releasing each other, or you'll have one party in the civil context. Usually, you have one party releasing if it's a settlement from a lawsuit. If it's a contractual settlement or a property settlement, maybe it's mutual. Both parties releasing each other, and really, what it boils down to is just saying that, look, we are done. We finalized the problems between us, whatever those may be, and you and I or us cannot commence any more litigation under the same set of facts.
Right, under this matter specifically, yeah.
And usually what we do is build into the releases the court file number or we'll do a description of the incident, or, in family law, it's fairly straightforward because it's just, it's the actual divorce or the property settlement between the parties. And it precludes you from recommencing litigation because once the release is done, money is exchanged, property is exchanged, then it would be unconscionable, as the courts find, to reopen that. But Matt's going to talk to you a little bit about, what context you can reopen it. But what is really important about full and final releases, which I think is interesting and what I really like to do, is building in NDA clauses.
Yeah, that's non-disclosure agreements.
Yeah, and I find NDAs really interesting, and I maybe that's my nerdy lawyer coming out in me, but it's an added layer of protection saying that, okay, we've now settled the issues between us as litigants, but I don't want you to go tell anybody about it because it's embarrassing to me, or it's, you know, as the defendant, I don't want anybody to know. And on top of that, I'm including a clause that says, I'm not admitting I did anything wrong. This is strictly so that we can stop litigating this. It's not an admission of liability, which is very important to a lot of people, because you're paying to settle the file more often than not, but you're not admitting that you did anything wrong.
Right.
If you want that admission that that party did something wrong, well, you're going to have to pay to go through a trial to get a judgment on that.
Especially if there's a reasonable offer on the table.
Exactly. And then so on top of that, I also like to build in clauses that say that, you know, you are not allowed to post this stuff on social media.
Sure.
You're not allowed to, you know, if it's in the context of, you know, if my client's a business, I'll say, you know, you're precluded from leaving negative reviews about my business. And if we see that it's a fundamental breach of the contract, we can ask for a judgment for the amount that we paid you back. And if you violate the terms of that contract and it's proven, then you consent to a judgment and you pay us that money back that we just paid you to settle, because it's a fundamental breach of that release.
Now, can a full and final release be set aside?
I think in our world, you know, the answer to that is it depends.
It's always
Yes.
it depends.
But
generally the answer is yes.
It can be if it's, again, it has to be litigated. There has to be good reasons as to why. And, you know, you've heard me say unconscionable before. If the contract is entered into without independent legal advice. Mm-hmm. So if one party has a lawyer, the other party, and that party drafted the release and it's given to a self-represented litigant and that person signs it because it means that they're going to take much less, like 25 cents on the dollar.
Right.
Is that duress? Is that, you know, should they have had an opportunity for legal advice?
The circumstances around the signature of the full and final release is also relevant.
Huge. And so I think to answer your question is yes. Now, my question to you is that in the work that you and I do, and specifically you're talking about spousal support, what happens with those releases? You know, we see it all the time, and courts actually will not order releases. They don't have jurisdiction to order releases, which is a common mistake we see sometimes.
We see people try to add those clauses into court orders because we have to draft the orders and the judge approves it. And oftentimes, if there is a release clause within the order, the judge will not sign it. And the reason being is that spousal support under, we'll say the Divorce Act specifically, but generally, divorce or spousal support orders or agreements have to follow, or at least be within the principles of the objectives of the Divorce Act. And that being said, in the event of a full and final release when it comes to spousal support, both parties are employed, both parties can support themselves. Maybe there isn't a we'll say solid claim for spousal support on the face of it. So they released each other from spousal support. However, upon a material change in circumstances, there could be a claim from the spouse that is now in need of support against their spouse if they have the ability to pay. Now you're going, well, why have these release clauses then? It's a good question, because there is case law that says you can have releases. You can have all the releases in the world, but upon a material change in circumstance, there might be a review of those clauses. There might be a review of the spousal support provisions to a point where all of a sudden you're paying spousal support because of that material change in circumstance. Now, that doesn't mean because you lost your job. That may not, you know, meet
You're
the
talking
entitlement.
like catastrophic
Where all of a sudden I can't work because of a disability. I can't work because of an illness, those types of situations. And then when it comes to property regime, a full and final release, they can be set aside if someone hasn't fully disclosed their assets. There wasn't independent legal advice because, again, there are issues of duress or things of that nature. So in the family law context, the most important things are for full and frank financial disclosure and obtaining independent legal advice outside of whomever drafted the agreement. If your counsel drafted the agreement, you get that advice. But if someone's sending you an agreement and you think it's fine, I'll sign it, it's always better to have a lawyer look at it and give you that advice, especially if you're going to sign a release.
Well, and I think I implore you, collective you, to think twice about downloading these internet agreements and signing them.
Yeah, there are issues with them.
Because in these internet separation agreements, we're seeing more and more today clients coming to us having already signed an internet separation agreement. I mean, I've seen it so many times. And there's like a 1-line clause in there that says spousal support, just both parties agree to release. Really, it's like a 2-line thing.
Yep.
And when you're sitting there talking about, I'm looking at my client and there's a giant income disparity, and I'm looking at them and saying, why on earth would you even sign this? Now, can we set it aside? Yes, those agreements can get set aside, because the easiest way is that neither of the parties have independent legal advice. Yep. So, of course, that's,
no disclosure.
That's like, no disclosure, 2 pinnacles of getting those set aside. But it adds a layer to the complexity of the litigation. So just don't do it. I mean, just don't do it. Like, I don't know how many
Simple
times
advice,
I can
but
say,
it's so important.
Just please don't do it. Spend the initial consult fee on a lawyer to review the document even before you sign it.
Yeah.
Don't come to me after it's signed, because then it adds a whole other dimension to what could have been a simple fix to something that's more difficult. So that's like, if you want my 2 cents today.
Yeah.
That's my 2 cents. Is I'm sick of seeing these separation agreements that are so bad for both parties. You just kind of want to look at them and be like,
let's start
this
from
up.
start from square one.
So,
so let's take a break.
Yeah.
We'll come back and
wrap it up.
We'll wrap it up. We discussed waivers. We discussed types of waivers, discussed basically what an occupier and owner should sort of look into a waiver, and then releases and what that entails, and if they can be set aside, and if to make sure that they're solid, make sure you get independent legal advice. And
I think all in all, productive discussion. I think that to more and more now, we just click on things, don't read them. How many times have you scrolled to the end of the thing and it's like, I just want to get what I'm getting. And I think that there is a lot of that goes on. It's important for people to just kind of rewind, reset, and, really look at what we are putting our signatures to, and what is important, what's not important.
It's a pretty good general life lesson, actually.
Yeah. Slow down. I think what I'm trying to say.
Slow down.
I think what I'm trying to say is slow down.
Welcome to psychotherapy with Deer.
Well, I mean, some days that's what I feel like, but
fair, very fair.
But this day and age is moving really quickly. We were just off, on break talking about ChatGPT. I don't know, maybe an episode coming about that at some point, but just reminds me that life is moving so fast, and in this digital world, in this AI age, we can miss things.
Yeah.
Right.
It's a great lesson, actually. I didn't expect that. That was solid.
I know. And it's, that's my, we did the soapboxes or whatever earlier. I'm just going to, go on that for a bit, but that's, I don't know. I find myself just wishing that we could slow down.
Oh my God. All right.
As a society.
No, I get it, Deer. It took a grim turn anyways.
It was all right.
That was pretty good too. So we need to do more of these episodes.
Yeah. I think that we, of course, whatever happens, but I love doing these. Being in the studio again reminds me of why we do it. It's for you guys. The content, continues to build up, and we just have to report on it. Essentially, we're like your live reporters on the law.
On the law. Reporters on the law. I like that.
Yeah. So we'll leave you with that. You can expect more from us. We're still alive. Don't worry. And we'll catch you next time. I'm Darren Chohan.
I'm Matt Butler. See you next time.